Ladies and gentlemen, all rise. Thank you for attending. This is the final round of the 2024 National Animal Law Competitions, and this will be the Appellate Advocacy round with the Honorable Justice Elizabeth Harris, Mary Hollingsworth, and Will Lowry presiding. Thank you. You may be seated.
Good afternoon, everyone. Thank you so much for being here. This is Cora Delgado versus Emmett Bagby and Pigtown Pastures. We have Petitioners Council and Respondents Council, and I think you've gone over the timekeeping aspect of this, yes? Any questions about the timekeeping? Okay. And are you planning to reserve any time for rebuttal? 2 minutes, okay? All right, thank you. Okay, so in that case, if the petitioners are ready, we are ready for you.
Thank you, and good afternoon, Your Honors. May it please the Court. My name is Taylor Rush, and I represent the appellant in this case, Cora Delgado. I will be speaking to Cora Delgado's permissive entry into bar number 3. Seated with me at council table is Drew McCormick. He will speak to the unlawful citizen's arrest of Delgado. This case is about protecting the rights of a reasonable Californian who was granted permission to tour a farm. Finding in favor of Emmett Bagby and Pigtown Pastures would set a dangerous precedent that expands what constitutes a civil trespass in the state of California. This could not be what the legislature intended when they passed the Agricultural Protection Zone Act, which I will refer to as the APZA moving forward.
Mr. Rush, wasn't that act spawned by animal activist activity? I mean, you're here on behalf of Ms. Delgado, but if I understand correctly, that act came about from open rescues and things like that. Is that not clearly the intent of the legislature?
The legislature did intend to prevent trespass, specifically because of these open rescues that have been occurring. However, here, the California civil trespass law, case law is pretty clear that in saying that Delgado trespassed, that would be an extension, it would go against the precedent that currently exists. And while it is true that she is an animal rights activist, she was not acting in her capacity as an animal rights activist when she was touring Pigtown Pastures. We respectfully ask this court to overturn the lower court's holdings on all 4 issues before you today. Because first, Delgado had permission to enter bar number 3. Secondly, Delgado was not the substantial
Counselor, how did Delgado have permission? It seems that the lower court ruled against your client on that issue, and aren't we essentially bound by the lower court's findings on that issue?
So this court should find that Delgado had permission to enter bar number 3 on the Pigtown Pastures property because of the words, conduct, and silence of Pigtown Pastures. This court is not held to the decision of the lower court. And because of the substantial evidence here today from the words, conduct, and silence of Pigtown Pastures, Delgado had permission to enter bar number 3.
Isn't the issue of consent an issue of fact, and wouldn't we therefore be bound by the lower court's
So the substantial,
findings?
sorry to cut you off, Your Honor. The substantial evidence test is not toothless. There is deference to the lower court, but it is not completely. This court does have the power to overturn the factual findings if there is substantial evidence supporting that the lower court got the facts wrong, which our position is that they did. So regarding—
Okay, I'm sorry, Ms. Rush, can I just clarify quickly? So your argument is that as a factual matter, there's no substantial evidence in the record to support the court's at least implicit finding that Ms. Delgado lacked consent to enter onto the property. Is that right? It's not that the court made an error of law or anything.
Correct, Your Honor. The facts in the record reflect that there is substantial evidence that she did have permission to enter bar number 3.
Counselor, I think you said earlier that Ms. Delgado was not on the farm in her capacity as an animal rights activist. I believe the record says that she was out scouting in the area of Clarabelle, looking for farms to possibly report criminal activity. And it is not the fact that she was on Mr. Bagby's property contrary to his interests, regardless of any other factors of consent. The fact that she's there as an animal rights activist and he does not know that, does that not negate consent?
No, Your Honor. So Bagby testifies on pages 18 through 19 of the trial transcript that the sign that allows people to come tour Pigtown property, the Pigtown Pastures property, the sign says all are welcome. And Bagby says all means all. So there is no misrepresentation of her being an animal rights activist. It would be unreasonable to inquire about the activities and the affiliations of every single person that comes onto your property. And the fact that she is an animal rights activist does not negate her consent. There was no misrepresentation of her activism.
Ms. Rush, I'm sorry, can I go back just for a second to the standard of review, just for a minute? It sounds like your argument is that there is substantial evidence that she had consent. But isn't our task at this point, we're not going to resolve any conflicts in the evidence. We're just going to look to see whether there's substantial evidence that she lacked consent. And if the answer to that question is yes, then aren't we bound by the trial court's ultimate judgment?
So, Your Honor, questions of law are reviewed under the de novo standard, questions of fact, the substantial evidence test. And here the trespass issue should be reviewed using the substantial evidence test because it is such a fact-reliant issue. And there is evidence that supports that she did in fact have permission. So
right, but my question is, even if there's evidence to support that she did have permission, if there is evidence to support that she didn't have permission, isn't that our task is to look to see if that's true or not, regardless of whether there might also be competing evidence that she did have consent?
In part, Your Honor, but because the facts that we have today are pretty clear that there is a reasonable person in Delgado's position could have believed that she did have consent. And according to Section 892 of the restatement, the second restatement of torts, which is adopted by California, consent is willingness in fact for conduct to occur. It may be manifested by action or inaction and need not be communicated to the actor. And it goes on to explain that if words or conduct are reasonably understood by another to be intended as consent, they constitute apparent consent and are as effective as consent in fact. And there are several California cases that involve whether or not consent can be used as an affirmative defense to trespass. In each of these cases, the courts discuss the ways in which the property owner plaintiff put the potential trespasser on notice that their consent to be on the property was limited. And this is true in Civic Western Corp, v. Zilla Industries, Inc., and Donahue Schreiber Realty Group v. New Creation Outreach.
But Counselor, doesn't Civic work against your case? I thought in that case, the business owners had rights to go in and remove property, but they changed the locks, they evicted employees. Is that not what Ms. Delgado did? She had rights to be on the property, but she went in and snooped around in a barn she wasn't supposed to be at?
So this case is different from that one because the court went in that case, they determined that the defendant had acted outside of the scope of consent because there was a lease in place, there was an agreement in place about what the conduct that would happen on the property, and they exceeded the scope of that, and the court spoke to how the trespasser was on notice of the limited consent.
But isn't this essentially the same? She asked for a tour. The employee took her to the areas of the farm that were part of the tour. The tour ended, which to me suggests that she was shown all the areas of the farm that she was allowed to see. And then she went off on her own looking in areas where she was not allowed, that were not part of the tour.
So on pages 38 through 39 of the trial transcript, Delgado explains how she went to the farm stand and was granted a tour. She was told that she would see, quote, the whole farm because Pigtown did not, quote, have anything to hide. And Holloway claims that she told Delgado that Barn 3 was not part of the tour at page 24 of the trial transcript. But Holloway also says that Delgado did not verbally acknowledge that instruction if it was even given. And what's more, Delgado says she was never told anything about barn number 3 at page 40. Delgado says...
But, Counselor, isn't the problem that the lower court found your client's testimony self-serving and did not actually agree that the evidence supported that conclusion? So again, back to my colleague's position, aren't we supposed to determine that the court's finding that there's substantial evidence that the court got it right?
So the lower court says, quote, Delgado's assertions are unsupported by anything in the record beyond Delgado's own self-serving statements. But this is not true. Given the testimony of what Delgado says she heard, the concessions of the Pigtown employees, and the number of things that Pigtown did not do to put Delgado on notice that her consent was limited. So nowhere in the record does it reflect that Delgado was told that she must follow Holloway around the property. At page 43, Delgado was not told that the tour was over. Delgado was left on the property alone when Holloway walked away from her at page 44, only feet away from barn number 3. But
counsel, if the facts in the record indicate that Holloway told Delgado she could not enter barn number 3 for biosecurity reasons, regardless of what Delgado says, given we're under the substantial evidence standard, does that not end the story right there? We defer to what Holloway said. She said, don't enter barn number 3, case closed.
No, Your Honor, because the Pigtown and Bagby must show that there is that Delgado's trespass is a substantial cause of a legally recognized harm, which she is not.
So I want to be clear. So are you conceding that if we accept that Holloway said don't enter barn number 3, we then move to your colleague and it's relying on his argument?
No, Your Honor. So the record reflects that there is evidence to show that Delgado was not on notice that her scope of consent to be on the property was limited. But even if this court were to decide and rule in favor of the lower court on this issue, turning to the second issue under the trespass issue being a substantial cause, Bagby and Pigtown fail because Delgado is not a substantial cause of a legally recognized harm. The California Constitution provides every person may speak freely, write, and publish her sentiments on all subjects, being responsible for the abuse of this right. A law may not restrain or abridge liberty of speech or press. Protected by the Constitution of the United States and the California Constitution, Delgado could speak freely about what she saw in barn number 3, even if this court were to decide that she did trespass. The courts have repeatedly recognized that the First Amendment may protect individuals who obtain and publish truthful information on matters of public significance. In Food Lion, Inc. v. Capital Cities ABC, that's a federal court case, but it is particularly instructive here. The Fourth Circuit held that Food Lion could not recover against Capital Cities, or they could recover against Capital Cities ABC for trespass and fraud, but they could not recover for anything that flowed from a broadcast, reasoning that the damages flowing from that broadcast would be in violation of the First Amendment. So that court awarded Food Lion $2 in nominal damages. And a number of courts have grappled with Food Lion and have applied it to animal welfare whistleblowers. And in every case thus far, Food Lion has been interpreted to grant First Amendment protections for their behavior. For example, ALDF v. Wasden, which also notably granted First Amendment protections to those who enter a property by misrepresentation.
Counsel, I just want to be clear. We've moved into the substantial factor analysis. Is that correct?
That is correct.
Okay.
Using Food Lion and ALDF v. Wasden, ALDF v. Wasden, it says that misrepresentation to enter a farm does not violate the consent to be on the property. And this is very instructive of how deep the First Amendment protections go. Applying Food Lion here, if this court were to determine that Delgado trespassed into barn number 3, Pigtown and Bagby could only recover damages for the harm done to the property. And there's no evidence in the record that reflects
The
that there was.
doesn't the state law very clearly allow for damages? I mean, right at this point where we are on appeal, the question is simply whether or not there was a superseding cause or whether or not your client was the cause of the harm. And given her steps, I mean, how could she not know that there was going to be a broadcast? I mean, it was probably the whole point of her contacting the news outlets.
Your Honor, if I may briefly conclude, because as I am out of time, if you look to the timeline in the trial transcript, there is several days that passed between the news broadcast and Delgado's entry into barn number 3, and the lower court awarded Bagby and Pigtown threefold their damages to recoup lost profits because of their violation of Proposition 2, and that is just not what the legislature intended with their enactment of the APCA.
Thank you, Ms. Rush. Okay, and now I think we're hearing from, on the second issue for respondent, is that right? Okay.
Good afternoon, and thank you, Your Honors. May it please the Court. My name is Drew McCormick, and I help represent the appellant in this case, Cora Delgado. As my co-counsel said, I will be speaking on the citizen's arrest issue. The Agricultural Protection Zone Act, known as the APCA, imposes reasonable limitations on a farmer trying to arrest another citizen. In order to have the lawful privilege to execute a citizen's arrest, Bagby must satisfy 3 requirements of the APCA. In this case, Bagby fails on all 3 of these issues. First, Bagby did not find Delgado in or on the barn number 3 as required per the APCA. Second, when Bagby arrested Delgado, it was not necessary to do so to protect people and property. And third, Bagby was not in the present and was not in the presence of Delgado when she entered barn number 3, and furthermore did not confirm with any one of his 5 senses that the offense had in fact occurred.
Let me ask you a question here. So once Delgado entered barn 3, then isn't she trespassing? Doesn't that trespass continue until she's off? Because at this point, she's already done something she's not supposed to do. So even though Bagby didn't see her in the barn, at that point, isn't she trespassing on the property?
Your Honor, that is not our position. Our position is that based on the words that were communicated to Delgado, she had permission to enter barn number 3. Language such as see where your pork comes from, all are welcome, see the whole
We
farm.
understand your position on the issue of consent, but let's say we disagree with you on that point. And the question is the presence component here. So once Delgado goes into the barn and trespasses, once she's in the barn without consent, doesn't everything she do after that just flow from that? Isn't she trespassing now on the farm? And therefore, once Bagby shows up and sees her, the trespass is in his presence?
No, Your Honor. Based on the language of the APCA, in order to execute a citizen's arrest, per section 19803, Bagby would have had to have found Delgado in or on barn number 3. And here in the trial transcript on page 12 and 19, Bagby admits that he had no idea what Delgado was doing in barn number 3, did not see Delgado enter or exit barn number 3, and to allow Bagby to arrest Delgado after the fact and based strictly on context clues would set a dangerous precedent where people could arrest others for false reasons.
Well, counsel, it's not totally on context clues because it's also, isn't it, based on his assistant, is it Holloway, her view of the trespass. She had information that she then communicated to Bagby.
Your Honor, that is true, but that is not sufficient for Bagby to execute the arrest. In fact, there's case law that discusses this, Hamburg v. Walmart, in which a Walmart manager relied on complaints of customers to justify arresting protesters. In that case, the court made it clear that relying strictly on the statements of other people was not sufficient enough to satisfy the presence requirement. And here, Again, Bagby did not see Delgado enter or exit bar number 3, and relying on Holloway's statements alone are insufficient to support that assertion.
Is it possible that Holloway could have delegated the arrest authority to Mr. Bagby, meaning that it occurred in the presence of Holloway, she then delegated the arrest? What's your response to that?
Your Honor, absolutely not. The way this law is written, Bagby cannot delegate that authority to, or Holloway cannot delegate the arresting authority to Bagby. Granted, California Penal Code Section 839 does allow people to delegate the arresting authority, but the way that the APCA is written, only an owner or occupier of the farm may execute the arrest. In this case, Holloway certainly does not meet the statutory definition of what an owner is. APCA Section 19801 makes it clear that an owner or occupier who would be authorized to execute the arrest must have control and greater impact on the farm. The facts here show that Delgado does not meet that definition, did not have control. On page 25, Holloway discusses her job duties, and it is clear that helping the pigs and following Bagby's orders does not establish Holloway as an owner-occupier per the APCA.
Where do you see the control language in the statute, Mr. McCormick?
Your Honor, Section 19801 D, an owner-occupier includes a person who has responsibility for and control over specific aspects of the farm. And here, Bagby makes it clear that he's the owner of the farm. Holloway is just an employee. If this law were to allow anybody on the farm to execute the arrest, then it would have been written differently. But here, the legislature used the specific word owner-occupier to limit the scope of what this law includes. Which brings me to my second point, the necessity of the arrest. When construing the language of this statute, it's important to look at the surrounding words of the statute. The lower court got one thing right, which is that the discretion granted to the arrestor does inform the meaning of what is necessary, when it is necessary to execute an arrest. Here, the law does limit the discretion of the arrestor. For one, it requires the arrestor to be in the presence of the offender. And second, unlike other laws of citizen's arrest, it must be necessary. And third, again, only an owner-occupier may execute the arrest.
Let's talk about this issue of what's necessary. What is the evidence in this statute that suggests that the legislature wanted that term to be read narrowly or strictly?
Your Honor, the lower court, as lower court articulated, and pursuant to California Civil Code Section 13, we have to use the surrounding words of the statute to inform the meaning of any given word. Additionally, as the lower court said, if the surrounding language limits the discretion of the person executing the arrest, then that would warrant a strict interpretation of necessary and require a higher threshold to satisfy the
But the lower court didn't think it should be read strictly, right?
That is true, Your Honor, but this is a question of law, a question of statutory interpretation, and those questions are reviewed on a de novo review standard. And for the reasons that I have stated, the necessary requirement should be construed narrowly and set a high threshold.
Why is this a question of law? I thought the Court of Appeals said that this was a question of fact. Or can you articulate more why we should view this as a question of law?
Yes, Your Honor, this is a question of law because we are trying to interpret the words of the law, not what happened, not a factual determination. We are discussing the meaning of the word, and for that reason, it is a question of law which warrants de novo review.
But when it's a mixed question of law and fact, don't we sort of look at what the predominant factor is? And I thought the Court of Appeals said it was the belief of Mr. Bagby, if Mr. Bagby thought it was necessary or not. Do you just discount that we need to consider that?
Your Honor, that is not reflected in the APCA language, and the language of the statute makes it clear that Bagby must do more than what he did in this case.
But doesn't the language of the statute seem to be extremely, protective of farmers? It seemed like the legislature really was trying to do everything it could to ensure that farms are not impacted by, out of control animal rights activists. So why wouldn't we take the lower court's view of the term necessary?
Your Honor, could you rephrase your question?
Sure. The text of the statute seems to support a broad interpretation of the word necessary. And I'm not hearing why, given the broad nature of this statute, why we wouldn't agree with the lower court's interpretation.
Yes, Your Honor. To answer your question, well, the surrounding language of Section 19803, where the word necessary is used, does actually limit the arresting ability of a farmer. Unlike other citizens arrest laws, this law requires that it be necessary to do so, and again, allows only owners and occupiers to execute the citizen's arrest. But again, if Bagby fails on any of these issues, then he did not have the lawful privilege to execute a citizen's arrest. So again, should you find in favor for Bagby on that issue, Bagby must still satisfy the presence requirement. And in this case,
I'm sorry, counsel, can I ask you, are you conceding that if we construe the word necessary broadly, as the Court of Appeals did, that then Bagby had a right to arrest Delgado?
No, Your Honor. Either way you interpret the word necessary, whether it be a strict or loose definition, at the time that Bagby arrested Delgado, it was no longer necessary to do so.
But if Bagby thought it was necessary, I mean, his testimony was that your client looked nervous, but he wasn't sure if she was going to attack, if she was maybe getting something from her car. I mean, if Bagby thought that it was necessary, isn't that the end of the inquiry?
That is not the end of the inquiry, because the law makes it very clear that relying on reasonable inferences and statements of others to confirm that an offense happened, per this law, the APCA, is insufficient. And there's case law that goes into that, discussing the presence requirement.
But Mr. McCormick, aside from relying on Ms. Holloway, at the moment Bagby was confronting Ms. Delgado at the car, he thought she was a threat. He thought she might attack Holloway, grab a weapon, whatever the case might be, regardless of what happened in barn number 3. If he thought it was necessary, is that the end? Is that sufficient? He thought there was necessary to protect either Holloway or his property based on what he physically saw. If we believe those facts to be true, do you concede that you don't win the necessary element?
No, Your Honor. Based on the way the APCA is written, it must be necessary to execute the arrest to protect people and property. It cannot be based on mere assumption and inference, which relates to the third issue, the presence requirement. Even if it was necessary, the presence requirement must be met. And the case law makes it clear that in order to satisfy the presence requirement, the arrestor must confirm with one of their 5 senses that an arrest has occurred. I expect my friends on the other side to bring up the People v. Bloom case, which established the presence requirement when a 911 dispatcher heard harassing phone calls. In that case, the dispatcher confirmed with her senses that an offense had happened. 41 calls was ample evidence to her senses to indicate that an offense had happened. Here, Bagby did not see Delgado enter or leave barn number 3, which he makes clear on pages 12 and 19 of the trial transcript. Furthermore, there's more case law that discusses the presence requirement and indicates that inferences alone are not sufficient to satisfy the presence requirement. Specifically, Leggett v. DiGiorno Company makes it clear that approaching somebody and inferring that they have committed a crime does not satisfy the presence requirement. And for those reasons, Bagby fails on every issue. Again, the language at the APCA is very clear that only an owner-occupier, therefore not Becky Holloway, must find somebody in or on the barn to execute the arrest. If the legislature wanted to allow Bagby to arrest Delgado based on inferences, they would not have written the law as such.
Let's say we agree with you on the false imprisonment component. What is your client seeking out of this case?
Your Honor, we are asking this court to overturn the ruling of the trial court and the Court of Appeals and hold her not liable for trespass in imposing those damages.
Aren't these two separate issues? Let's say we agree with Bagby on the trespass issue, but agree with you on the false imprisonment issue. What is your client seeking?
Well, Your Honor, in order to execute a citizen's arrest, a crime must have actually been committed. And Collins v. Owens makes that very clear, where people saw somebody who they assumed was intoxicated and arrested them, and in that case they found that the presence requirement was not met. May I briefly conclude?
Yes.
In this case, Emmett Bagby did not have the lawful privilege to execute a citizen's arrest, especially when considering that Delgado was given apparent consent to enter barn number 3. And for those reasons, we ask you to find Delgado not liable. Thank you.
Thank you very much. And now we are ready to hear from Respondents' Counsel.
Madam Chief Justice, Your Honors, and may it please the Court. My name is Angelina Popovic, and I, along with my co-counsel, Ms. Delari Cooper, represent the respondent, Mr. Bagby and Pigtown Pastures, in this matter, on behalf of Team 4691. This case is about upholding California legislators' intent of the APCA by recognizing farm owners' right to protect their property and animals. I will be addressing why Ms. Delgado meandering into barn number 3 constitutes trespass, and my co-counsel will be addressing why apprehending a trespasser was a lawful citizen's arrest. We respectfully request that this court affirm the 5th District holding for 2 reasons. First, Ms. Delgado had no consent to enter barn number 3, which held pregnant hogs, and 2, Ms. Delgado was a substantial factor in Mr. Bagby's losses.
If your clients are inviting people onto the property, they're allowing them to move around where the barns are without an employee being present, I mean, isn't it really your client's responsibility to identify off-limits areas or identify, maybe marking them as agricultural protection zones?
No, Your Honor, because Mr. Bagby in the sign posted that if citizens wanted to see the farm, they needed to go to the farm stand to get a farm tour, and these were guided tours. So these tours consent was only given to see the farm with someone else present, guiding them through, and Ms. Delgado listened to the sign by going to the farm stand and asking for a tour, and then later did not listen by going off by herself and exceeding the scope of consent.
Counselor, to your point about guided tours, when Ms. Holloway and Ms. Delgado were in the parking lot near the end, there's no evidence in the record that Ms. Holloway said the tour is over, you should leave. Is that correct?
There is evidence, Your Honor, that Ms. Holloway waved and walked off, and Ms. Delgado says herself in the trial transcript that she saw her wave. And further, Ms. Delgado's own attorney states that Ms. Delgado was left in the parking lot. On page 33 of the trial transcript, it states that she was left in the parking lot in front of the farm stand, which is where the tour began. So when one is brought back to where the tour began and they're left literally standing in the parking lot and the tour guide walks away waving, it's very clear that the tour has ended at this time.
Ms. Popovich, can I back up for 1 second and ask you a clarifying question about the standard of review? So you agree that under California law, consent can be implied, correct?
Yes, Your Honor, consent can be implied.
Okay, so then in this case, and it sounds like what Ms. Delgado is arguing, is that a reasonable person under these circumstances would have believed that she had consent to enter into barn number 3. And so my question would be, isn't that illegal? issue that we would review de novo whether the historical facts that are found by the trial judge would put a reasonable person on notice that they have consent. Why isn't that a question that we would review de novo?
Your Honor, it's not a legal issue, it's a fact issue because there is conflicting testimony in the record about whether or not Ms. Delgado was put on notice about whether Barn 3 was included in the tour and whether she was allowed to go off. Because Ms. Delgado states that Ms. Delgado contends that Ms. Holloway stated that she could see the whole farm and that she can see Ms. Delgado contends that she can see the whole farm, but Ms. Holloway doesn't agree that she made that statement. And further, Ms. Holloway is sure that she stated that Barn 3 is off limits for biosecurity reasons, but Ms. Delgado doesn't agree with that. So there are fact issues, and this is not a question of law here.
What if we agreed that with the facts that support the court's ultimate judgment, so we look at the facts in the light most favorable to the judgment, and then say, okay, fine, those are the facts, and now we get to decide as a matter of law whether those facts would put a reasonable person on notice that they did or did not have consent. And I guess one of the reasons why I ask is there's a case that's cited in the Court of Appeals opinion, the Crocker Bank versus San Francisco, where the issue was whether or not something counted as a fixture. And the court said, well, we'll accept what the trial court says about the fixture, but whether or not it amounts to whether or not it should be taxed as part of the real property, a reasonable person would think that it should be. That's a question of law for the court. So that's why I'm thinking, wouldn't that be something that we would decide? We would take the facts in the light most favorable to the judgment and then decide whether that would put a reasonable person on notice of consent.
Yes, Your Honor. If you were to hold that, you would find that it does not put a reasonable person on notice because on page 14 of the trial transcript, it states that 521 people have toured this farm before, and Ms. Delgado was the one who had issues with the scope of the tour and went off on her own. Everyone else, 520 people, went with the tour with their tour guide and had no issues. And further, reasonable belief is not under both Smith v. Cap Concrete and Miller v. National Broadcast. Reasonableness doesn't matter in the consent analysis. Smith v. Cap, in 1982, this court held that good faith, honest belief about where they are permitted to go is irrelevant to the consent analysis. And in Miller, this court further expanded on that holding, stating that a good faith belief that a trespasser has consent, even if reasonable, is still not sufficient. So regardless of whether Ms. Delgado's belief was reasonable, she still did not have consent to tour the barn, and she was a trespasser.
Here's what I'm having trouble with is how isn't Ms. Delgado's entry into Barn 3 substantially the same conduct as the entry into Barn 1 and 2?
Yes, Your Honor, it is not substantially the same conduct because the sign found on Exhibit 1, page 3 of the record, page 2 of the record, it gave consent to guided tours, not to wander the tour on their own. Because it said, if you want a tour, come to the farm stand. And if it was not guided tours, it would have said, come by and explore the farm.
Well, didn't it say come see where your food is coming from? And in fact, Barn 3 shows that the pork is coming from pigs held in gestation crates?
Yes, Your Honor, and the petitioner cherry picks this fact. However, saying that see where your pork comes from doesn't mean that they get to see the whole life cycle of the pigs or how your pork comes to be from start to finish, which are the conclusions that Ms. Delgado drew on page 36 and 37 of the trial transcript. However, this is quite a stretch from the limited wording on the sign. The purpose of the sign is to advertise tours, to let people know that they can go to the farm and get a tour. And the purpose of the statement, see where your pork comes from, is likely to let people know that they will be seeing exclusively pigs on this farm. Because the majority of people likely don't know that some farms only contain pigs. They might, if it only posted farm tours, it may give the impression that they might see cows and other farm animals. So saying see where your pork comes from gives that impression. And further, it does not
But
say.
okay, hold on.
Yes.
But, I mean, doesn't your client say that, after the state ballot initiatives and sort of the concerns regarding how animals are raised for meat, that part of the impetus to allowing these tours and allowing people to see is to show that they are actually treating their animals well. And in fact, what they were hiding in barn number 3 is, pigs, sows in gestation crates, which violates the law.
No, Your Honor, the respondents were not hiding the pigs in that farm. They simply, they never offered farm tours in barn 3, and they kept barn 3 locked from the public. They kept barn 3 away from the public because of biosecurity concerns. Because while hogs are in their gestational period, there are very serious concerns that they'll be exposed to any particles. The barn must be sealed in order to keep them safe from air, weather, bugs. Any of those things can get them very sick, and it can pass to the children, the infants as well.
Counsel, yes.
Go right ahead.
I have a number of questions on causation.
That's where I was headed.
So I would, if you don't mind, I'd like to turn there. I guess my first question would be in response to the petitioner's argument. Is there any case where a plaintiff has recovered publication damages, which is essentially what Mr. Bagby is asking for, on a trespass claim?
Your Honor, there are similar cases, not necessarily publication damages. However, there is a strong.
But isn't that really the root of what Mr. Bagby is complaining about? He's saying his reputation was damaged by the story. And your opponents are saying, well, you can't get that kind of damage. You can't get those damages, publication type damages under Food Lion and all of the cases following Food Lion on a trespass claim.
This is a unique case in the fact that it comes from publication damages from a trespass claim, but under the substantial factor analysis, Mr. Bagby should prevail because under Ralph's Grocery Store v. Victory Consultants, a defendant's conduct is a substantial factor if a reasonable person sees it as one. So it is not relevant whether this damage could have been caused in any other way. And it's not relevant whether Mr. Bagby is a substantial factor. The question before this court is whether Ms. Delgado was a substantial factor.
Counsel, can you explain more how it's not relevant if it could be caused another way? So why is the KCRA news story, the CDFA visit, why are those not superseding causes and the true causation versus Ms. Delgado?
Yes, Your Honor, because the harm here was the severance of the Uncle Nelly's contract and the loss of sales in the farm stand. And Ms. Delgado trespassed to see the hogs in barn number 3, and she called the CDFA and the KCRA. And the KCRA, on page 6, it states that they acted off of Ms. Delgado's tip because otherwise they would not have known. And further, they also acted off of the CDFA information, and that was also gained from Ms. Delgado's tip, separate tip. So all roads lead to Ms. Delgado.
So your position is basically that she set in motion a chain of events that ended with the publication of the information and then the loss of the contract. Is that your position, that that's sufficient, that she has set in motion this chain of events?
Yes, Your Honor, because she did more than just one act to set it in motion. She trespassed, which endangered the animals because they were in a very
Well, that he didn't get damages for endangering the animals, did he? Was that part of the damages?
No, because this case is an outlier in the fact that the hogs were slaughtered after giving birth because of the way that they came from the neighbor. However, this court cannot decide based on an outlier, even though there were not biosecurity hazards that came from this. There will be in most cases. There are a lot of statistics from the CDC showing that humans coming into a barn while hogs are in their gestational period without any masks or the proper clothing to keep the hogs safe is extremely dangerous.
Well, if that were in the record and also if those were the damages, I think that the court would likely agree with you on that. But can I ask you a hypothetical based on your theory of causation? What if instead of foreclosure, having the pigs end up at Mr. Bagby's farm, what if a farm worker at the neighboring farm had negligently destroyed the barn there? And so then the pigs went over to Mr. Bagby's farm, and then somebody discovered the pigs there, and he lost the contract. So is your position then that the farm worker from the neighbor's farm who negligently damaged that barn is now responsible for Mr. Bagby's lost profits, that whoever put this in motion is ultimately responsible for all of the injuries?
Your Honor, seeing as my time has expired, may I answer your question and briefly conclude?
Yes, please.
Could you briefly re-summarize your question?
Yes.
Thank you.
My question is, there is no backstop on the but-for causation theory that you have? Because isn't it true that under your theory, if the pigs ended up at Mr. Bagby's farm because of some negligent conduct by the neighbor's farmhand, under your theory, the neighbor's farmhand would now be responsible for paying Mr. Bagby's lost profits from the canceled contract? Doesn't that seem a little attenuated for causation purposes?
No, Your Honor, because this is not a but-for standard. A but-for standard is very low for causation. This is a higher standard of substantial factor, and Ms. Delgado meets that because under Ralph's Grocery Store v. Victory Consultants, it asks whether a reasonable person would find the defendant's conduct to be the cause. And here, considering she tipped off the KCRA and the CDFA, and the KCRA could not have acted and run this story without the tip from the CDFA, and they would have not known without her. She is a substantial factor. So Mr. Bagby should prevail in this matter. For these reasons, the respondent respectfully asks this court to affirm the 5th District holding and find that Ms. Delgado trespassed and caused Pigtown's damages. Thank you.
Thank you very much, counsel.
Madam Chief Justice, Your Honor, and may it please the court. My name is Delari Cooper, and as my co-counsel mentioned, I represent the respondent, Mr. Emmett Bagby and Pigtown Pastures in this matter. I will be addressing the second issue on appeal today regarding whether Mr. Bagby had the lawful privilege to conduct the citizen's arrest of Ms. Delgado. This case is about allowing farm owners to exercise the rights they are statutorily entitled to under the APCA. Mr. Bagby's conduct complied with the standards set in the APCA, and therefore he conducted a proper citizen's arrest.
Counsel, how do you respond to your opponent's comment about the wording that Mr. Bagby must find the person in or on the farm? So Section 1903 talks about must find the person. Mr. Bagby, according to the record, did not find Ms. Delgado in the barn. How do you respond to their argument there?
Your Honor, based on the intent of the APCA and the legislator, it is clear they intended to allow the farm owners to conduct a citizen's arrest as long as the individual is still within the protected farmland. Here, Ms. Delgado was still within the farm. She was in the parking lot at the time the citizen's arrest was conducted. Therefore, she was still within that agricultural protection zone.
But isn't that a separate part of the statute? I mean, the first part of the statute says who finds a person in or on an animal protection zone, and then later in the statute talks about if the person is still located. So your opponent's focusing on the first part, the fines.
Your Honor, based on that specific section, it also says that it is where the animals may be located or kept. If you consider where they may be located, it would be reasonable to consider that a hog may escape one of the barns and enter the parking lot since it is so close to barn 3. With this consideration in mind, the respondent claims that this would be within the agricultural protection zone as defined in the APCA.
So your position is that Bagby saw the petitioner for the first time by the car. So at the point at which he saw Ms. Delgado, she's already almost to her car, and yet you should expect that animals are going to flee a barn, which is what your colleague described as being sealed and locked down because it's a biosecurity issue. But we should expect that the pigs are going to somehow escape and make it to the parking lot. That's your argument?
No, Your Honor. My argument is that considering the definition of the agricultural protection zone, as well as the intent of the APCA in the legislature, this would be considered an agricultural protection zone based on the fact that it is still located within the farm and is readily accessible from the barn number 3 and other areas in the farm.
Counsel, if we find that Ms. Delgado did not commit a trespass, does that make Mr. Bagby automatically liable for false imprisonment, given he did not have a lawful privilege?
Your Honor, no, because although that the court may find that there was no trespass, this is the intent of Mr. Bagby should be considered at the time the citizen's arrest was conducted. At this time, there was a reasonable belief by Mr. Bagby that a citizen's arrest was necessary for the protection of persons and properties on his farm.
So let me ask you a question about that. So I have a hypothetical. Let's say your client got mugged a few years ago by a blonde person and has an irrational fear of people with blonde hair. When he sees a person with blonde hair on his property, he thinks that person is going to cause harm to a person or an animal on his property and arrests that person. Is it your position that as long as your client believed that the person was a risk to the property or person, that would be enough to meet the standard?
No, Your Honor. Under those circumstances, that would not be a reasonable belief.
What? So as long as but who determines whether or not Bagby had a reasonable belief about the necessity of arresting?
The lower court establishes that the reasonable belief is that of a reasonable person. Here, considering the facts of this specific case, it was reasonable for Mr. Bagby to conduct a citizen's arrest because Ms. Delgado showed a disregard for the rules of Pigtown Pastures.
But didn't the lower court focus in on Bagby's subjective beliefs?
Yes, Your Honor.
They didn't apply a reasonable person standard.
Yes, Your Honor. However, in previous case law cited by the lower courts in the California Appellate courts, a reasonable belief standard can be used. Additionally, considering the standard used by the lower court, based on Mr. Bagby's subjective understanding of the situation, based on him seeing Ms. Delgado head towards her car in a fast pace as well as being confronted by Ms. Holloway, this is evidence that Mr. Bagby had a reasonable belief that Ms. Delgado was attempting to flee after she had trespassed in bar number 3.
Can I follow up on that? Because I think that Mr. Bagby had to have a reasonable belief that the arrest was necessary for the protection of persons and property, not a reasonable belief that the person might flee. So what are the circumstances that show that he had an objectively reasonable belief that the arrest was necessary for the protection of persons and property?
Your Honor, at this time, Ms. Delgado had already shown a blatant disregard for the rules set forth to her by Ms. Holloway, as well as the rules of Pigtown Pastures. She was acting in a way that was reckless and endangered the animals at Pigtown Pastures.
What was the evidence that the animals were endangered? Because now this is the second time I think I've heard that, and I'm just not sure what's in the record to support that.
Your Honor, the APCA protects against harms such as disease, illness, as well as stress to the animals.
Right, but at the point that Bagby confronted her, she's already practically to her car. I mean, she's nowhere near the animals. It's not like she's fleeing with a piglet in hand. I mean, what's the harm here?
The harm here is that the pigs and hogs in their gestational period are extremely susceptible to illnesses, disease, and stress. These are not readily ascertainable by looking for a brief moment in time. Therefore, Mr. Bagby could have the reasonable belief that it was necessary to confine and do a citizen's arrest of Ms. Delgado at this time.
But isn't the problem that he didn't actually see the violation? I mean, don't you have a problem there that it wasn't in his presence? I mean, maybe if he had seen her engaging the piglets and touching them and all that stuff, that would be a different situation, but.
So under the case law of People v. Lee, which was a case that was decided in the California courts, it was established that when a shoplifter had taken an amount of clothing into the dressing room, the arrestor did not see the individual when they were in the private dressing room. However, when the individual came out with less articles of clothing than they entered the dressing room with, this was enough to establish the presence requirement. The petitioner misrepresents what is necessary to meet the presence requirement under the APCA.
But counsel, isn't that different than the facts here? I mean, Mr. Bagby didn't see Ms. Delgado go into the barn like your case. They saw them go into the dressing room. So is that not a little bit different? Maybe he saw her walking towards her car, but you're missing other facts. He didn't see her go in. He didn't see her carrying anything. How do you make sense of that?
Your Honor, the People v. Lee case is similar to this case because although Mr. Bagby did not see her enter or exit the barn, there was enough evidence to understand and appreciate that a trespass had occurred. His agent, Ms. Holloway, saw her as she hastily walked away from barn number 3. Additionally, the fact that Mr. Bagby attempted to use less restrictive measures to understand the harm that may have been caused by Ms. Delgado, this also shows that it was necessary for him to conduct the citizen's arrest.
Let me go back to, I'm sorry to interrupt, to your Lee case. Let's change the facts of Lee a little bit, and let's say a security guard watches somebody go into the room with clothing, and then a separate cashier sees that person come out with less clothing. Is that in the presence? Would you find the presence requirement met there?
Yes, Your Honor. Under the precedent of the People v. Lee case, it is established that if the arrestor sees, one, that a public offense has occurred, or they are told that a public offense occurred, and there's other evidence to establish that a crime has occurred, this is enough to require the presence requirement under Section 837 of the California Penal Code. Additionally, in the Lee case, as well as the Gomez v. Garcia, it is clear that presence is interpreted liberally. Additionally, when you consider the presence requirement under the APCA, here, Mr. Bagby saw that the door was ajar, which the record states is not the policy of the farm. Additionally, he saw Ms. Holloway and Ms. Delgado having an exchange by her vehicle.
Let me ask you, sorry, let me just cut you off because I want to make sure we get to this point. What, in your view, is the standard of review for the issue of whether or not the arrest itself was necessary?
Your Honor, the petitioner misrepresents the standard of review in this case. As the lower court has established, this case is under the substantial evidence standard. This standard requires that the facts of the case be looked at in the light most favorable to the decision of the lower court. This is established in the record on—
But counsel, don't we have to look at legislative history? We have to interpret the rest of the statute. That all feels like legal work. Why is that not a question of law that should be decided de novo?
Your Honor, although there is questions of law that are relevant to this case, as established in the Crocker National Bank versus City of San Francisco case, which is on page 7 of the record, when a question is a mixed question of law and fact, but the case requires that the primary issue is that of a factual nature, the substantial evidence standard of review should apply. Additionally, on page 9 of the record, the lower court states that although the examination of the APCA is relevant, the question hinges less on the legislative intent and more related to the subjective belief of Mr. Bagby at the time and under the circumstances.
Let's say we
that
don't
he
buy
conducted.
that. And, again, going back to the issue of necessary, we're talking about allowing a member of the public to arrest somebody, which is serious business, right? Why wouldn't we take the position that necessary should be, strictly interpreted?
Your Honor, based on the intention of the legislature as well as the APCA, it is clear they are intending to use the more broad definition as to this case. Additionally, our government is a system of checks and balances. The legislature creates the law, and the job of the court is to apply the law. Here, it is not the intention of the court to rewrite the law. It is clear Mr. Bagby's conduct did comply with the intention of the legislature
Right, but
in enacting the APCA.
necessary wasn't defined by the legislature. It is our role as judges to interpret what necessary means for purposes of this statute. So, again, given the seriousness of arresting somebody and having a member of the public arrest somebody, why wouldn't we take a strict view of what necessary means?
Your Honor, it is our position that the lower court has already applied the meaning of necessary. In the San Francisco firefighters versus City of San Francisco case, it is determined that the word necessary can have multiple meanings. However, the word should be— May I briefly conclude, Your Honor? I see that I'm out of time.
Yes.
Thank you. The term necessary should be considered under the context of the statute as a whole. Under the statute of the APCA, it is clear that they intend to provide broad discretion to the farm owners in assessing what is necessary in this context. Mr. Bagby conducted a lawful citizen's arrest upon Ms. Delgado's trespass. For the aforementioned reasons, we ask that the court respectfully affirm the decision of the 5th District Court. Thank you.
Thank you, Ms. Cooper. And I think, do the petitioners have time left for rebuttal?
Yes, Your Honor, 2 minutes.
Great, then please come on up.
Thank you again, Your Honors. In this case, Delgado had permission to enter bar number 3. The language makes that very clear. The sign said, "See where your works come from. All are welcome." During the tour, Becky Holloway said, "You get to see the whole farm and that Pigtown has nothing to hide." What's more is...
Again, though, to that point, the lower court did not agree that the evidence supported that conclusion. And so isn't our role to determine that there's substantial evidence to support the lower court's conclusion? I mean, the lower court didn't agree with you on that point.
Your Honor, interpreting what is consent is arguably a question of law and warrants de novo review. Furthermore, this court is not bound to the lower court's holdings on fact findings if they were clearly erroneous, and with the given language that was articulated Delgado, permission was granted. But what's more is that Bagby also fails on the other issues. The substantial cause of harm is not a legally recognized harm.
Isn't consent typically an issue of fact?
Typically, but in this case, it really hinges on the legal definition of what constitutes consent. And in that regard, this court is free to review it.
Do you have any cases supporting your conclusion that the issue of consent is a question of law?
Your Honor, I don't have any case law on that specifically, but even regardless of that issue, Bagby fails on the other issues which he must satisfy. The First Amendment protects Delgado's right to inform the public that Bagby was breaking the law. If the court were to hold otherwise, then Delgado could have witnessed a murder scene and been prohibited from telling people about what she saw. In this case, it is not appropriate to hold Delgado liable for those damages.
Isn't witnessing a murder scene different than entering a barn without permission?
Your Honor, it's related because Delgado witnessed violation of the law in barn number 3.
But the way she did that was arguably by breaking the law, correct? So that's a pretty key difference.
Your Honor, the First Amendment time is concluded. May I briefly respond?
Yes.
The First Amendment protects Delgado's right to inform the news that Bagby broke the law. For those reasons that we've articulated, we ask that you overturn the lower court and hold Delgado not liable. Thank you.
Thank you. And thank you to all counsel for your excellent arguments. Congratulations to the students on a wonderful last round, and the court will be in recess.
All rise. Everybody hang out. The judges are going to confer for a moment, then they'll come back out and offer some feedback.